Hello, my name is Jonelle Oldacre, an attorney with the Cummings Law Firm. On January 8th, I will host a discussion on managing risk on the job site via commercial general liability policies and indemnification clauses. Please see below for more details on this free event. This topic is so important to every player on the construction site. Insurance in general is complicated, and we tend to want to defer to insurance agents to sell us the right policies. However, it's important to understand what you're paying for. The purpose of a CGL policy is to protect the insured and additional insureds from liability against damage and personal injury at the job site during the policy period. Protection from liability is the key wording here. The policy is typically designed to protect from third-party claims and lawsuits for negligent acts or accidents. The most common CGL policies are claims-made and occurrence-based policies. A claims-made policy is designed to cover claims for damage or injury that occur during the policy period. Claims made after the policy has expired are generally denied. An occurrence-based policy acts to cover claims for damage or injury that occurred during the policy period, regardless of when the claim is made. Determining which policy is right for the job requires a close look at the budget and the particular risks associated with the work to be done. Once you understand what is covered by your policy, the next step is to carefully examine the named exclusions. The primary purpose of a CGL policy is to protect the insured from third-party claims. Thus, there is often no coverage for the insured's own loss or injury. Additionally, CGL policies do not cover workers' compensation claims. It is important to take a close look at the named exclusions in your policy and purchase the proper endorsements or additional coverage to fill those gaps. The most intimidating clause a subcontractor can face in a subcontract agreement is the indemnification clause. However, an enforceable clause can also act to protect you against lower-level subcontractors, so they should be embraced. In addition, the language in the clause, like the whole contract, is negotiable. Now, I understand that a subcontractor is eager to accept a particular job, may not want to risk losing it trying to negotiate the terms of the contract. However, failure to do so could cost so much more. Fortunately, Texas offers some protections, but it is always better to negotiate beneficial terms up front. A consultation with an insurance broker that has extensive experience within the construction industry is crucial to ensure you purchase the right product and secure the needed endorsements. Further, engaging the services of an experienced attorney to draft or review a prime or subcontract agreement can greatly reduce your exposure. If you would like to learn more about this topic, feel free to check out our blog at thecrommingslawfirm.com.